Presenting this round will be 7 panels for one break. Mike Horshat, Greg Rory, Jake Steinberg, myself, Pat Rickle, Alex Potsbach, Ed Hebert, and Kevin Greenberg. In that case, I'd like to call this order. The government team ready? Yep. Is the opposition team ready? I call this order and call upon the Prime Minister to deliver a speech now produced in 7 minutes on top of the story.
Thank you very much, Mr. Speaker. It's a pleasure to be here this afternoon. Most states have requirements, statutory requirements, that in order to be eligible for parole, a criminal must confess to the crime he's committed. What we want to propose in our side of the House today is that anyone should be eligible for parole, even if they refuse to admit guilt to the crime for which they've been convicted. So at the beginning of their eligible parole period, as defined by the sentence that they've been given, even if they refuse to admit guilt to the crime, they would still have a hearing and still have the possibility of proving that they're deserving of parole. We have 3 arguments on our side of the House today. First of all, we believe that there are legitimate reasons not to confess, and the state should not coerce individuals to confessing in these instances for the sake of receiving a shorter sentence. First of all, we'd like to talk about the possibility of wrongfully convicted. Now, we all recognize that there's a certain percentage of people which will always be wrongfully convicted, or more accurately, that a certain percentage of the prison population will always be wrongfully convicted. We think it's unfair to force people to confess simply for maintaining their innocence. In particular, if we look on a systematic or aggregate level, we then see that individuals who were wrongfully were innocent will on the whole get longer sentences than individuals who actually committed a crime. We think this counters for most fundamental perceptions of justice and something which we should not structurally incentivize. But secondly, what we say in our side of the House is that forced confessions remove a check on the system. And it's a check of innocent people pushing to declare their innocence to show that they are wrongfully convicted. If an individual has to confess, usually it's interpreted in society as he actually being guilty. It takes away most momentum from his movement to show that he's not innocent. And in fact, it hides systematic biases within the system. If people tend to be the victims of the system, or certain groups of people tend to suffer more than others, but they can no longer maintain their innocence or have a tremendous incentive to confess to crimes they didn't commit, then the check of people disagreeing and protesting is removed. The final argument we'd like to make on our side of the House under this idea of wrongfully convicted is that individuals who are wrongfully convicted can often bring civil suits against individuals, or can often bring civil suits against the police for the way in which they've conducted their inquiry or their trial or the investigation, or against other members of the judiciary. But if you've had some kind of confession in the past, that clearly weighs against any case you can bring in the future, and any types of rectification, not just for the outcome, but for the procedures that were used, the investigation, the original violations of your rights. The second argument we'd like to make under this idea of legitimate reasons not to confess is the idea of fear of retribution. Because we think a lot of people don't confess to a crime even when they committed it, because they fear retribution from others. This is particularly true in instances of collective crime, when an individual is a member of a gang, and his confession reflects in some way on other individuals. And that's present in 2 cases. First of all, when other individuals within this gang or some criminal enterprise have been convicted but still maintain their innocence. In a situation where one individual's confession clearly impacts our judgment in society whether these other people are guilty, then clearly there's tremendous pressure on this individual not to confess, and therefore tremendous risk that he will experience some type of reprisal when released in society for confessing. But secondly, what we say is that even if these individuals have not been convicted, clearly when some individuals confess, it casts a shadow of guilt on other individuals who were never tried, destroys their public reputation, or leads the police to investigate and scrutinize these other people much more severely than they would have otherwise. We think both of these facts lead to the possibility of retribution, and we think it's fair and just for an individual to be unwilling to confess in response to these issues. The second argument we'd like to make on our side of the House today is that we believe that our position is consistent and better fulfills the purposes of justice. Now, what are those purposes of justice? Well, when we set a sentence, we set it a maximum sentence, and we say that that's the maximum amount that we can fairly punish a person. In other words, his moral desert does not justify any more punishment than that maximum. We also set a minimum. That's the parole level, when you become eligible for parole. We say any punishment less than this is too low, is not justified on deserved grounds. Both in that range of between the minimum and maximum punishments on deserved, we try to choose what the ideal punishment is on grounds of social utility, what's in the best interest of society. And simply because this individual is not confessed does not mean it's not in the best interest of society to release this individual. And we see that for a number of practical reasons. First of all, the shortage of prison space which often exists and often leads us to have to release others so that we can keep some people in jail for longer periods of time. But secondly, the tremendous cost of keeping people in jail. But we think it's highly unlikely that they're going to reoffend. It clearly seems that it's not in society's interest to keep them in the penitentiary system. But I'll take you on that point. The final argument we raise under this argument, therefore, is that we ultimately that there are utility harms on the families. Clearly, it's better that people get reintegrated into society as quickly as possible, as a general principle. First of all, we want them to provide for their families, get reintegrated into their families, and we also know that prison tends to be criminogenic. The longer people spend in prison, the more likely they're recidivised, the more likely to maintain criminal life. Now, these are important considerations we always take into account when setting sentences, and it doesn't seem like we should forego the possibility of taking these considerations into account in this instance because an individual is refused to provide a confession. The final argument we'd like to give on our side post is that we believe forced confessions are meaningless. They don't achieve their purpose in the justice system, and they don't in any way better fulfill the purposes of justice. And why do we see that? Because an individual would make the decision to confess or not purely on cost-benefit analysis, clearly whether it's in his long-term interest to do this. And because there's such a tremendous incentive, ultimately you'll be detained, denied the basic freedoms of life unless you confess. An individual is purely confessing for that particular reason. Now, we don't think that offers any of the type of consolation or satisfaction that a victim wants, that the person is perhaps confessing only because he's doing it to get out of prison. But furthermore, on a moral level, clearly, a coerced confession doesn't have much moral significance, is not much of a sign of remorse. But finally, what we say under this point is that it devalues the voluntary confessions which do exist. People do become remorseful at times in prison. They do confess to the crimes they've committed. But in this particular instance, for a victim, they're not going to be able to distinguish between one type of confession and another. And as a result, the entire enterprise, if apologies have any value, the entire enterprise of apology is devalued. So therefore, what we see? We see, first of all, that the victims are not better off as a result of this policy. Secondly, that we don't think society is better off because the purposes of the justice system are not fulfilled as they should be. And third of all, that individuals have legitimate reasons for not confessing, are often coerced into confessing to their own harm and to the harm of everyone else. For those reasons, we're proud of it.
Thanks, Sergeant. For all the by the way, the judge will be detained once your grace out period is issues. All right. I think Sergeant Strickler's remarks to call upon the leader of the opposition to deliver the first opposition.
All right, thanks very much, Mr. Speaker, for coming out and judging this round. Everyone in this tremendously august panel for judging. Everyone in the House, for and for what's been a really fantastic Nationals. It's the best one I've ever been to. It's been great. Side government for a really interesting case, and Robbie for being a great partner for 4 years and hopefully a few more rounds. That said, Mr. Speaker, I want to start with an observation before I move into my independent points. And I want to talk in my observation about what I really think the idea of parole actually is, and why we think when you consider what parole is actually all about, it seems like having things like forced confession in order to get parole seems absolutely necessary to fulfilling what parole means. What Robbie and I believe parole means, Mr. Speaker, is a means of advancing social utility to a large degree. It's not about the rights of the individual, because the rights have already been adjudicated during the criminal proceedings. That we derive more utility from this process by making people confess, then I think all the rights arguments go out the window at the point where one, already assuming these individuals are guilty, and two, better fulfilling what parole is actually about, which is benefiting society on the whole. And through my independent points, I'm going to explain exactly how that process comes about. The first thing I want to talk about is the idea of remorse, a functional, necessary functionality of parole. Why is remorse important? Well, what I'd say first is what I mentioned a minute ago, which is parole boards necessarily must assume that the individual they are evaluating is guilty of the crime they committed. First, it's true because if that were not the case, it would signify a real sort of loss of faith in the criminal justice system. Now, we recognize in reality that there are sometimes wrongful convictions. The problem is when you're evaluating these parolees on an individualized basis, you don't think in terms of the broad generalities of the system. You ask yourself whether you believe the system worked for that person, and in each circumstance you do that, you will reach the conclusion that it did. Because if it did not, there are procedural checks in place, the appellate process and things like that, or would be exonerated if you were in fact wrongly convicted. So it seems like on an individualized basis, the parole board would conclude that the conviction was correct. This individual was not wrongfully accused and wrongfully convicted. It stems from that, Mr. Speaker, that when they are in prison, one of the functions of prison is to make them better for when they are reintegrated into society. And one of the things that we think is utterly important for things like, not going out and committing other crimes, recidivism and things like that is, are they remorseful for the initial crime that they are in jail for having committed? Because if they can show that they they are remorseful, that is one of the many things, one of the most important things that parole boards should evaluate when wondering whether or not the sort of incapacitative function of the prison system has actually served its ends. Because if they aren't remorseful and they aren't demonstrating that remorse, from the perspective of the parole board, you have someone who seems very clearly to have been convicted of the crime and is unremorseful for that crime. That's a person who, as long as the state says they should be in jail, should continue to be in jail.
How does this argument generate remorse, or make it easier for us to distinguish between the people who are remorseful and those who are not?
We don't necessarily believe this process generates remorse. What it does is evaluate the extent to which the remorse already exists. We think that's the necessary functionality of the process. So if that's the case, if this does provide a means of evaluating whether or not remorse happens, what we think is that it's absolutely necessary to the functionality of the system, right? Like, if you're a parole board and you think someone isn't remorseful, it stands to reason from that they might go out and commit other crimes because they clearly aren't sorry for the crimes they have committed. The second thing I want to talk about are other sort of broad societal benefits, specifically the benefits that come about when you just have confessions in general, specifically with regards to prosecuting other criminals. What we can say is oftentimes this can be used as leverage for getting individuals to sort of give up information about others in society. They talk about gangs and things like that. I think that's an argument that flows to our side of the house. The one where having this incentive in place means you're more likely to get things like individuals coming out and confessing and talking about others and getting like protection once they're out on parole. But the other thing I'd say here is, think about all the arguments they make on the case with regards to things like how this is coercive and how this forces confessions and things like that outside of a right structure. Recognize, Mr. Speaker, that all these things are exactly the same when you're dealing with things like the plea bargaining system, where oftentimes you get to reduce sentences out there if you're willing to confess to a crime. All of their arguments, if taken to their logical extreme, would say that plea bargainings are also wrong. But we would never say that because we think it's first and foremost the individual's choice. Even if there is an incentive structure in place that might push that choice in one direction, we still recognize the autonomy of the individual. And more importantly, we balance that incentive structure against the societal benefits which stem from that confession. And we think when you're doing that, especially with regards to parole, obviously those societal benefits flow side opposition because you're able to incarcerate more people, fight more crime. The final thing I want to talk about off case, though, deals with the idea of utility through closure. And they're going to say on their side of the house that you don't get real closure when you have this sort of forced confession, forced parole. But what I'd say, though, Mr. Speaker, is first and foremost, it's not just like the guy goes, okay, I did it, and then like he gets let out on parole. It's a very evaluative process. The parole board is not just evaluating whether or not they say they confess. They're evaluating things like, are they actually remorseful for the crime? And that is actual, like, is actually the confession that's at play there. So at the point where it's, again, a parole board making the determination of whether or not this individual is actually remorseful for the crime, we can see then that if the state is willing to acknowledge that individual's remorse, we think it provides better closure for the rest of society, better closure for the victims, better closure for everyone who's involved in the crime, which Robbie and I believe is necessary, no thanks to get back on the case, which is necessary for things like moving on, and again, the functionality of our justice system. Part of our justice system is not just to punish individuals for the sake of punishment. It's so that when we punish them, we are getting something back from them for the rest of society. Society can grow and move on from their lives. That said, going back to the case, the first thing they talk about is that this is really coercive. But recognize again what I just told you off case, that all these arguments under this would apply with as equal, if not more weight when dealing with the plea bargaining structure. We think that's important. I'll tell you why we think that's important after I say first what that's promised.
In general, the reason we have plea bargains is for reasons of expediency, so we can possibly more trials. It seems like in this instance, expediency lies on our side of the house because we can take utility considerations into account in a way that this eligibility requirement does not allow us to do.
This is like a cross-applied around deal. If we demonstrate that more utility and more expediency on our side of the house, then yes, we get to win that argument. I mean, come on, like that's really not a meaningful, independent response to this. But they say that first of all, the wrongfully convicted stand to lose a lot in this circumstance. Again, I think, Mr. Speaker, that even in a generalized sense that there are wrongfully convicted individuals, that can never be an assumption that a parole board makes when evaluating a criminal individually. The other thing I'd say, though, when they talk about removing the check on the system and things like that, is we actually think this is an important check on the system. Because we recognize, again, that one of the fundamental aspects of the system is to provide society with someone, let people out of jails when they are ready to be let out of jail. This utterly removes that check at the point where you're saying we're willing to let someone out of jail who's not demonstrated their contrition and demonstrated their remorse. They talk about hiding discrimination and things like that. But the other thing I'd say in response to all of these arguments is I think there's low impact to the extent that there are very, very few individuals who find themselves in this situation. So again, like, while this might be true in like 1 in 10,000 cases, like I don't think we should be basing the entire functionality of our criminal justice system around this premise. So thank you. They talk about things like fear of retribution and things like that, and the sort of shadow of guilt that would follow these individuals. Mr. Speaker, I think that's sort of a silly argument. At the point where you'd be willing to say that we would always consider things like confessions in a criminal proceeding, and we would always provide incentive to confess in other areas. Again, like I think this is just something that I've talked about a lot. That is how similar this is to things like plea bargaining. But more importantly, Mr. Speaker, again, when we recognize that the individual is autonomous enough to make the decision as to whether or not they are contrite for their crimes, we also recognize the individual is autonomous enough to weigh the things like fear of retribution and fear of retaliation. They talk about how this is consistent and better fulfills the purpose of the justice system. And they talk about the maximum sentence and social utility. I think we've explained how social utility falls to our side of the house. Again, that's why we have parole in the first place. They talk about families and reintegration, but that only works if they can express remorse, and that's an evaluated remorse. I think we get better remorse on our side of the house, because just saying I'm remorseful for a crime I didn't commit doesn't make any sense whatsoever. The final thing they talk about is forced confessions are meaningless. Again, Mr. Speaker, at the point where we're evaluating these, we can determine whether or not these are just forced confessions or whether or not these individuals actually are contrite for their crimes. So I think we've explained to you on our side of the house why it's not just checking a box and getting let out of jail. It's actually a process where we best fulfill social utility through an evaluative mechanism that determines whether these individuals actually are remorseful. And forced confession is essential to this process.
Okay, when we remarks, I call upon the member of government to go to 30 seconds speech. Not to exceed 8 minutes.
Let's start with two brief overviews. The first thing that I'd say is Chris is correct when he tells you that the parole process is an evaluative process. Just saying I'm guilty doesn't get you parole. Here's the problem though. If you don't say it first, you don't even go to the parole board. It's a non-starter unless you've already confessed guilt, which means we can't have the rest of the evaluative process. But Rory and I's position is these other things might be more important than this one stupid, yeah, I did it confession, and you should be able to factor all of them in. Any argument that they told you that, yeah, I did it's not going to get you anywhere, is an argument on our side of the house, because that's what gets you through the door. If it's meaningless, then it shouldn't be the gatekeeper to get you through the door to have this big evaluative process. This is really important subject for us. The second overview I'd like to make, though, is that they keep making analogies to plea bargains. Here's the problem. They're making an argument, a descriptive claim. This is the way plea bargains made. There's never the prescriptive argument. They're just saying be consistent. Never that plea bargains are a good thing necessarily. There's easily arguments that plea bargains are unnecessarily important. But Rory points out to you, however, the reason we have plea bargains, the reason that we have plea bargains is because otherwise we simply couldn't handle the load. That is, there's just not enough time to prosecute everyone. It's an argument for expediency. But then look to where Chris drops Rory's arguments about expediency, that prisons are overcrowded. So the expediency analogy actually shows you we're being consistent with plea bargains. There's no non-starter to plea bargains in the same way that I think doesn't allow you to look in the other ways. This is really important. We think that this is about a situation. Now look at Chris's observation. He says that what's important is to look at the idea of parole, and that we think that where the idea of parole isn't about whether or not rights are violated, it's about utility. First off, I reject the premise because some people are consistently having their rights violated, and that's why and being in front of the full parole board is just a reflection of that. That is, the people that have innocently been convicted, or the people that are being mistreated in prison, are having their rights violated, and this is problematic. But additionally, keeping someone, once they've sort of reformed themselves in other ways, in prison a day longer than socially necessary is violating their rights. This is another rights violation. But on top of this, when he tells you it's just about social utility, no thank you, I think what we'd say is that we can outweigh the social utility when we tell you that the forced coercion is meaningless, because as he tells you, saying, yeah, I did it, isn't going to be the gatekeeper in this way. Now let's drop down. The first thing that he talks about is remorse. And he says, look, the parole boards must assume guilt. I'm not sure that this is necessarily true that they have to assume guilt, but we can accept that the parole board's assuming guilt, right? That doesn't mean that there aren't legitimate reasons that guilty people wouldn't want to confess. Rory gives you two, which is the fear of reprisal, and he later concedes that it's unnecessarily coercive. So you're putting the people in this situation where they have to choose between their freedom and their lives in many cases, or this reprisal, and reprisal to their families. So these are innocent bystanders where maybe the gang member themselves doesn't care and doesn't care about the reprisal, but the reprisal might fall on the family or some other innocent person. This is problematic, no thank you. But what we'd say on top of this is also problematic under the fears of reprisal and there's reasons to assume guilt, is that there's collateral harms that occur on this, and that once you confess, it can be used against you in other settings, and there's a social stigma attached to it. This can come up in civil court, it can come up when you're trying to get a job, all kinds of problems. The next thing, however, they tell you about, sure thing, Robbie.
Right, there's a social stigma to confessing to a crime, there's not a social stigma to being convicted of a crime.
If you have the chance of maintaining your innocence, I think that's a little better off. But once the parole board said that the thing thing is, the way that you can get rid of that social stigma in a lot of ways is getting parole and having the parole board say, look, this person doesn't deserve to be in prison anymore. When you have this sort of gatekeeper preventing people from getting to the parole board, the social stigma is magnified in many ways because they're kept in prison longer, so it's more difficult to get a job. If you've been in prison for like 8 years, it's going to be more difficult to get jobs if you're in 3. Look at Rory's argument when he tells you that prisons are just criminal factories, and staying in prison longer makes you more likely to be a criminal and more likely to have recidivism. Which is the next point that he makes, that you have to have remorse to have recidivism. But additionally, on top of this, that we'd say that remorse is something you internalize, it's not something that you say, and the parole board can evaluate whether or not someone feels sorry for something without saying that they're guilty, or saying that they're guilty exactly to the crime that they've convicted for. It might be true that you might think that something that you did maybe caused harm to this person, but that doesn't mean you think that you're guilty of the charges you were convicted of necessarily, or that you don't think that you were wronged by the system procedurally. Remember the argument he told you that this masks systematic oppression. But he told you its full impact when he says that there's not many people that it's going to come up. Remember, we don't know whether there's not a lot of people because everyone's from forced to saying they were guilty. So we have this false impression of our mind that innocent people aren't in prison. Why? Because they all confessed because they were forced into it. This is problematic. The second independent point that he told you is about the broad social benefits. He only mentioned one thing of these broad social benefits that he tries to balance against everything that's around, right? He's like, we have these broad social benefits. The ones we have, we can leverage people to dining out their buddies, right? And he thinks that this is so valuable. But what we tell you is that there's the fear of reprisal, but additionally, the role of the plea bargaining system, that he tells you is just to articulate social utility, shouldn't be trying to force people into this situation to coerce. It's just trying to say whether or not it can be a meaningful part of society again. During the trial process, it should have been where you tried to coerce them to dining out their buddies by plea bargaining or offer shortening sentences. If they haven't done it yet, there's no reason to hold their convictions against them in this way. This is problematic. Then he makes the plea bargaining point cross-apply what I already said. That said, his third independent point is utility through closure. First, I want to reject the premise that you get closure by someone saying that they're guilty. This is problematic for the victim. In many ways, it reopens the wounds that is problematic, but they now can't even hold the mindset and that maybe it wasn't the case that this person committed the crime, especially if they're suspicious of the judicial process. This is problematic because it's often the case that the victim thinks that the person that's being convicted didn't actually commit the crime and someone was just pulled off the streets. This makes people more of hate the judicial system more. No, thank you. But the thing that we say on top of this is, if it's an innocent person and you think that there's closure for the family of the victim, right, but it's an innocent person that committed the crime, here's the problem. That inverse amount of sort of closure that they get is visited upon the family of the innocent person. They suffer again. That is, now their family can't maintain their innocence, and they have this feeling of guilt. This is problematic because they don't have that closure, and they actually have a negative closure, and it's innocent people that are suffering the most. But even more so, victims' rights aren't what's important in the judicial system because it's a crime against the state. It's an evaluation of this. The victim can take you to civil court, that's fine. That's their role. We shouldn't be valuing someone's rights and leveraging their rights against the victim necessarily, because that would lead us to the conclusion that we can do anything that would make it so that the victim was placated. I don't think that this is the case. You can't keep people in prison unnecessarily long to keep the victim happy. You shouldn't put someone to death to keep the victim happy, and you shouldn't hold someone and ban them from getting parole to keep the victim happy. It's not that. That's not the role of the system. That said, now move back case side. The first independent point Rory tells you is that there's legitimate reasons not to confess. Once again, we hear from Pratt that this should never be an assumption of the plea system. What we're telling you on our side of the house right now is that this is the gatekeeper, that you can't get in front of the parole board, and the parole board can factor in these other things. But what they don't respond to is our collateral harms of confessing for innocent people. They just say, look, I don't think that this happens very often. But what he drops is the masking argument that we make, which is that we never know if there's systematic discrimination because you coerce the innocent people to throwing away their rights. What Rory additionally tells you, it might be the case that we're consistently convicting a particular type of person, and that we're like innocent, right? Like young black men, it doesn't matter which one, will throw any one of them in jail just to placate the victim, right? And if it's a particular type of victim, they're also going to confess in this way, so we can't figure out systematic harms either. Either way, we don't know the impact. But Rory also makes another argument that we think is pretty interesting, which is if the innocent person doesn't confess, they actually serve a longer sentence than a guilty person. This is really, 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 really bad. And the innocent person stays longer than the guilty person. The next argument that we make under the same first point vote is the fear of reprisals. They said these aren't the kind of things that we should factor in. So on their side of the house, it's okay to factor in collateral damages and social benefits. But on our side of the house, it's not. But we think this is not that's what the position they're taking. But I think this is an unreasonable burden to put on these individuals, the coercion behind it, because it's the judicial system not respecting their rights. The second independent we said is it doesn't fulfill the justification of punishment. They said they get better remorse, but they did respond to Rory's argument later on where he said that this isn't meaningful remorse because you don't internalize it. But ultimately the value for the remorse of all of it actually meant it, and it makes it more difficult to tell the difference between the two. This is problematic because the way that you get a benefit from remorse is believing that it's the truth. The way that we can believe it's the truth is when people aren't coerced into giving it. This means that the victim is better off. It means that the person itself actually internalizes it and move on. All of these things are valuable. We're proud to propose.
Thank the member for his remarks. Call upon the member of the opposition and thank the Pratt for the final
Thank you for everyone coming out to this round. It's most guest house, most guest panel. Chris for a fantastic week. Bill for a really interesting case. Adam for, I'm sure, writing in the back. That being said,
This one's actually not mine.
they've learned well.
They're beating you by a lot, but not quite that.
That being said, I want to respond to two observations again. The first thing they say is, well, these things are used as a non-starter rather than as an evaluative process. Couldn't we use it as an evaluative process? I don't understand why it has to be a gatekeeper on our side of the house, right? What their case statement was, as I understand it, was anyone should be eligible for parole even if they do not confess. So what they're saying is never use it as a factor. We can use that as a factor. It doesn't have to be like the only thing that gets you to the room. I think we can defend that on our side of the house, right? Like it is something that can be considered and a factor within the process. I think we can exclude some people on that ground. We don't have to exclude everyone on that ground. I think that's what we can do on our side of the house. But even if you don't believe that, I'll take it a little bit later. I think we can say that on our side of the house that that's still something that we think we should consider. Because realistically, remember what Chris tells you, is that how can you necessarily be remorseful for a crime you say you didn't commit, right? That just doesn't make any sense. Yes, they have some good arguments on their side of the house about how people will be prone to confess and things like that. But people who aren't confessing this stuff, they definitely aren't remorseful for that crime because they aren't even willing to acknowledge that they're responsible for that crime. I think it's a little bit disingenuous on their side of the house to say that, well, only innocent people would be willing to say that, like, they didn't do this crime and things like that. Because there are a lot of people in jail who still, one, say they're innocent, but two, want to come out of jail and say they're innocent as well. And I think on our side of the house, we're okay with saying that they should give up that claim and should not be able to stand up there and still say they are innocent, even if they're not. The other over we get is, well, we talk about plea bargains. We never necessarily defend them. I think to a certain extent, like, we do defend, right? Like, we talk, like, even they defend on their side, right? They talk about how utilities can factor in this round, how that's something to evaluate this on. But I think the other thing I'd say in response to this is just, in those circumstances, we accept all of the harms they talk about as rights, right? Like, their first point, right? They say, what if people are wrongfully convicted? This removes the check. They can't bring civil suits. Those are all arguments against doing plea bargaining as well, because they are coerced into saying they did something that they may not have done. Sure.
My response to this was saying that you just said that we should be consistent with plea bargaining and didn't defend them. That's why I also made the arguments why our side of the house might lead you to conclude plea bargaining are wrong. Citing an example of consistency, how is that an argument?
Right. The argument we were making was that, generally speaking, these are things that are derived based on utility, and we are always willing to defend on our side of the house a parole system that's based on utility, just like plea. Going to the argument's my partner, yes. The first thing he talks about is the idea of parole, and he talks about how it's a means of social thing, usually. Again, they talk about innocence. I think first, we don't design the criminal justice system based on innocence. For example, think about jails, right? We don't put people in different places, like, we have everyone in one area. Some innocent people might be in the same place as guilty people. We don't say, oh, those innocent people might be in the same place as guilty people, right? We look to expedience go up those cases. They talk about, well, what about these reform people? It's a rights violation on their part to keep them in jail a day longer that they're in there. Like, that's the flash in the ground. We're saying that no one can necessarily be reformed unless they're coming out there and saying, I committed this crime. Let's talk about remorse. And we say, we must assume guilt. And they say, why do we have to assume guilt? I think the parole board has to assume guilt insofar as it shouldn't be going back through and trying to, like, evaluate every case on its own, right? Like, that's probably pretty inconsistent justice. But the second thing I say, though, is the point where the parole board is going, oh, maybe they might have been, but maybe they weren't quite correct. Then at that point, like, what is to stop them from granting parole to a lot of people who shouldn't have been granted parole, right? I think at the point where they're willing to go back and try those cases again, you don't get that accuracy. We talk about function of prison as being a rehabilitative system. And they say, well, there are reasons for these individuals to confess, like reprisals and things like that. Okay, maybe that's the case. Maybe a lot of people will be confessing, and maybe only half of them will be actually accurate. What Chris and I are saying is you can actually go through and evaluate that kind of thing. It is used within the process. They first confess, and then they go through and decide whether or not they believe that confession to actually contribute, whether or not it actually. I think a lot of the arguments that they make on their side house are predicated on the notion that parole boards have no heads. This seems like a silly assumption on their side of the house, and I think we can assume that if these groups are good enough to go through and, as they're apparently on their side of the house, like these groups are so good that they can accurately decide the minute somebody is rehabilitated, but they can't go through and decide whether or not someone is remorseful in their confession. I think that's a contradiction. We talk about how remorse goes through rehabilitation. They give this social stigma argument. Again, we say that social stigma probably exists at the moment that you're convicted. They say, well, they can still say they're innocent. Dude, I was totally wrongfully convicted. It's probably not going to fly within society. They talk about recidivism. They say, well, we talk about how they're remorseful without false imprisonment and things like that, and they say people who are remorseful and are still in prison, that's necessarily bad. Like, I think what Chris and I would talk about on our side of the house is that people who aren't willing to admit to the crime they can, admit to the crime that they did, aren't in a position to be set back into society because they have necessarily not even admitted to themselves and admitted to those around them. They are responsible for that action. I think a lot of reasons that people commit crimes are because of responsibility, and when they aren't even willing to hold themselves responsible for that, or admit in public I did it, they can't necessarily go out there and be rehabilitated. No thank you. The second thing we talk about are these broad social benefits. Chris talks about leveraging people to give up information. I think the response we get to this is pretty silly. They said, this should have happened at the trial. Okay, if it happened at the trial and they confessed there's no rounds because they've already confessed. They've already said, I'm guilty of this crime. So, at that point, we have to ask, do we want these people to confess later? Probably do, insofar as there's other information that could be valuable to society. So the only way this argument makes sense is if you buy that everyone who's being up for parole has already confessed to the crime, in which case their case makes about as much sense as, man, I didn't set that joke up. The other thing I understand response to this is, what's the flip side? The thing we say, though, is then, if that's not the case, then they didn't necessarily have a confession at trial, maybe they were convicted without those other facts getting out there, that's stuff we can get on our side house. Again, social utility. The third thing we talk about is utility for closure. They say it opens up old wounds, like releasing the people doesn't open up. They talk about, again, what about the innocents? What about them? We shouldn't design our criminal justice system, or specifically just say, well, innocents might be getting screwed over, might as well make the system as lax as possible. That seems kind of silly. We talk about how we get better relations with victims. They say we can't keep people in jail to keep the victim happy. But it's not like that's the only reason they're there. We're saying remorse goes to whether or not they will commit a crime again, but also, like, to a certain extent, we can. Like, retribution is valued within society, and I think making victims happy is something that society should take into consideration. Going back to the side, no, I'm just kidding. They talk about how people who are forced to confess and reasons to confess and things like that, or reasons not to confess. They say that wrongfully convicted removes the check and can bring civil suits. One, if this is as coercive as they say, where like that can actually be evaluated when they bring a civil suit. Honestly, if there's enough information that is there to exonerate them so that they could sue the government, they could present that. The government could say, well, you said you were guilty, and if it's so coercive, they could say to them, I totally just wanted to get out of parole. If that's the case, I think all these arguments drop out. They say, well, it doesn't bring this issue to the forefront to the point where, like, people aren't standing up. If they say they're guilty, we assume no innocent people are in jail. That argument is very, very silly. I think that to a certain extent, everyone accepts that there are problems with the system. But secondly, I don't think how parole, when people stand up there and say I'm innocent, is necessarily going to lead to any kind of check or change at the point where, presumably, if their case means anything, there are people right now saying I am innocent and no change has occurred. They talk about how people fear retribution. Chris says we like confessions and things like that. They say collateral damage matters on both sides. Again, I don't think that matters when we get that better on our side of the house. They talk about consistent justice. They say it devalues other ones because you can't tell the difference. Again, they have heads. They can evaluate remorse. They have to get through the door by saying this is something illegal. They talk about how there's a cost to keep them in jail. What if it's a necessary cost? What if these people should be in jail? It's a privilege to be let out early, and that's something they have to earn. They talk about the enforcement confessions, not the real ones. Sure, but we think victims have some rights on our side of the house. They should be able to see some closure, and that definitely can't happen on their side of the house, at the point where people don't even accept responsibility for their crimes.
Any member for remarks and call upon the leader of the opposition to move the first row of around it, not to exceed 5 minutes.
Very nice.
Mark, thank you once again, Mr. Speaker, everyone in the panel, everyone in the House, both sides, praise Rory for making this outstanding debate. The prisoner, the citizen, and the rest of society. I want to talk about the prisoner first and the idea of individual autonomy that we talked about in LOC that gets no response from the community. What we tell you, Mr. Speaker, is it's okay to put prisoners in this situation for a couple of reasons. First, we say they are equipped to evaluate, to make these decisions, even in potentially coercive environments. Because remember what Robbie and I have been telling you throughout the round, Mr. Speaker. This is not coercive in the sense that we are putting a punishment on these individuals for not confessing. The state has already levied a punishment against these individuals. By letting them out early, we are offering them a privilege in response to their confession. I think that's why it's disanalogous to say that this is a coercive procedure, that we are punishing these individuals and consequently violating their rights. At the point where we're willing to say that individuals have autonomy to evaluate fear and things like that when they plea bargain, or when they confess, or when they turn state's evidence, or even when they go to the police, it's unreasonable to say that just because these individuals now have another incentive in place, another incentive at work, that all of a sudden we should stop evaluating their autonomy and stop being willing to say that their autonomy is The analogy I draw is something along the lines of, imagine if I were to give Chilton $1,000 to like take his clothes off and run through the hotel lobby. Something he probably wouldn't want to do. But the money I'm offering him, to the extent that it's a privilege, it's a benefit, it might be somewhat coercive in the sense that it forces him to make a choice, but it's not coercive in the sense that I'm violating his rights by putting him in that position. One of the states already levies the punishment. We respect the prisoner's autonomy. That's the distinction we're willing to draw. Remorse is also important here, and what I think we've shown throughout the round is, if you believe, as I think they've conceded, that remorse is necessary to reintegration into society, because you cannot be reintegrated at the point where you are unwilling to acknowledge past actions that you committed. At the point where they concede that, I don't think that goes challenged by the member of government. I think Robbie and I have said, and it's inside government's burden to contradict this or rebut this, that acknowledging that the crime has been committed is necessary to expressing remorse. They've never challenged the notion. In fact, the member of government sort of blatantly asserts that maybe there are other ways of getting remorse without confession. That doesn't make any sense! Obviously, you have to acknowledge that the crime has been committed, and remorse is important. They've never challenged that. The government has had to show why offering a benefit is coercive. They've not. So the second thing I'm crystallizing on, though, is the system. We talk about how this is a gatekeeper and how this is part of an overall evaluation. What Robbie and I say is, yes, they should have to confess before they get into the room. Confession is a necessary, but not a sufficient condition to being paroled. That's why we're able to claim broad social benefits, because it's not just someone saying, I'm doing this to get out of jail. If they were just doing it to get out of jail, they would check the yes box, check the confession box, and then go in there, and a parole board, which they've already conceded is evaluated to, or equipped to evaluate these things, would say and see that they are not equipped to be released from jail because they are not actually contrite. They have not actually expressed remorse for this crime. So if that's actually the case, then I think that it's very clearly close to our side of the House that we're okay with having this necessary condition in place. Because again, I don't think you're going to see the harms that they talk about, where individuals are sort of confessing to crimes just to get out of jail, the sort of bad, the sort of bad situation they talk about. The other thing I want to talk about in the system is the idea of assumption of guilt, because they make a lot of arguments about innocent individuals. We've given you some excellent replies, I think. We first and foremost said that the innocent and the wrongfully convicted have many legal avenues through which they can pursue their claims, but the parole hearing is not one of them. Because even though we have been making general claims and ideas about the justice system, parole boards have to evaluate these individuals on the basis they have been correctly convicted, because the member of government does not respond to, otherwise it would show a severe lack of faith in the justice system, severe increased opposition, and a less procedurally checked environment of the actual outcome of the justice system. They need to show that that system should not be that way, and the parole board should be questioning the guilt of these individuals. I don't think they've done so, and if they haven't done so, then you can't take into account things like it might this individual be wrongfully convicted. Finally, I'm going to crystallize on the rest of society, because I think we've shown that through things like plea bargaining, through things like this confession for parole, we get broad societal benefits. We've told you that the parole hearing isn't about rights. That's what the trial is for. That's what the courts are for. It's about expediency, as they even assert on their side of the House. We get better closure on our side of the House because these confessions seem legitimate. We get more people in jail because they're confessing and sending others to jail. Society is better on our side of the House, Mr. Speaker, and the system that they propose simply does not make sense if you think that expressing remorse is necessary to being let out of jail on parole. We think it is. They've asserted that you don't need to confess to express remorse. That's just silly. Vote opposite.
Any leader for remarks? We call on the Prime Minister to conclude the round. The rebuttal speech and
Here. Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to begin with Robbie's mischaracterization of our case. Our case today was that confession should not be a necessary requirement for parole, but he mischaracterizes when it says it can never be a factor. If parole boards want to take it into account, we think it should be given very little weight for all of the reasons we talked about, how coerced confessions are meaningless, but it can still take into consent with into consideration with all of the other factors. The interesting thing in our case is that if there's someone who we deem it in society's interest to release, we shouldn't not benefit society simply because he hasn't confessed. We're talking about this being a gatekeeper, about a statutory requirement just to be eligible for parole, not the factors they should take into account when assessing parole. And Robbie mischaracterized it, misunderstanding it when he says that says there are two issues in this round. First of all, I'd just like to compare the two sides. What are the benefits of their system with the benefits of theirs? Their system, they say, is a utility system. It's based on benefiting society to the greatest extent possible. That's interesting, because we provided a theory of the justice system which they never refute. It was that a punishment, the maximum amount that is set, is what we can fairly punish someone to the maximum amount, and the minimum amount, when you become eligible for parole after a certain point in time, is the minimum you have to punish them, and then anywhere in there, you use the parole hearing to decide, is it in society's interest to release them at a particular point in time. The parole mechanism is a mechanism for assessing utility effects and society's interest. We allow for these parole hearings, therefore we allow for society's utility to be taken into account. But they don't even allow these parole hearings to take place, which is strange if utility is the #1 factor on their side of the house. The next argument they give is that they'll be less recidivism on their side of the house. But they never tell us why coerced consent is meaningful, why it will generate remorse. When I ask them will it generate remorse, they admit that it won't generate remorse. If that's the case, it doesn't seem like these people are going to be more likely to reintegrate into society. They're going to be the same people. Because we recognize that autonomy is only meaningful if it's made as a free choice, not as a coerced choice, not because you don't want to spend 3, 4, 5 more years in prison. So it's clear that the person is not going to change as a result of this requirement. But furthermore, they talk about we're going to get better reintegration of these criminals. And we think that's funny because one of the great utility considerations we always want to take into account is the criminogenic properties of prison, and they never discuss this on their side of those. It's clearly something that we balance along with many other factors than punishment, and we clearly can in this situation. Is this person going to be better off if he's released now rather than in 4, 5, or 10 years? It's clearly a question the parole board should ask. Next, they give us on their side of the house the possibility of more convictions. They say that we can use this to get convictions against other individuals. But first of all, clearly, we all think, or we've argued on our side of the house, that perhaps there's something wrong with coercing one individual to testify or give evidence against another person. That's why we disputed this idea of plea bargains. In fact, there's a case that people often run. Plea bargains, forced plea bargains in exchange for testimony against other individuals are unfair. Clearly, they just can't assume because we do this in one situation with plea bargains, we can do it in another. But furthermore, we're admitting this is not the correct way to go about that. So if you want to construct a fair justice system, you don't threaten people with punishment unless they're going to testify and infringe the rights of other individuals. That clearly counters our notion of fairness within the system. The final argument they give us on their side of the house is that it's going to allow for easier parole hearings because the parole board won't have to revisit all of the issues that occurred originally in the trial. But they say that what should be considered here is society's utility. So ultimately, we look at the factors of, is society better off? Not whether this person originally committed the crime or not. It doesn't seem like we have to revisit the original trial. We just have to have a parole hearing on whether society is better off if we release this particular individual. Now, clearly, remorse is often a sign of an individual being able to be safe to release, but they never give us a factor of how we mechanism by how we distinguish those who really did confess meaningfully and those who didn't. At this point, this argument doesn't hold. Then I'd like to look at the benefits that we've given on our side of the house. First of all, we talked about the wrongfully convicted. Robbie makes an interesting response. He says, the system is not designed for the interest of the innocent. In fact, we say that's precisely the opposite. We designed the system with all kinds of safeguards in place, and we do know that despite all these safeguards, a certain percentage of people are wrongfully convicted. Given that, to a certain extent, it seems like if we can build in another check without sacrificing any meaningful social benefit, then it seems like furthermore, they never respond to the intuition that it's clearly unjust to have a system which systematically puts the innocent in jail for longer periods of time than the guilty. Clearly, this is something and something we're addressing on our side of the house. But finally, we talk about checks on systematic discrimination within the system. And once again, they don't have an effective response. There are certain groups of people tend to be disadvantaged in the system. This is the only way we find out, because if they have to confess, no one takes their pleas of innocence seriously within society. As a result, it's very difficult to change the system. So even if they make the argument that the system looks perfect now, clearly we can't assess the perfection of the system because of the requirement of coerced confession. The final argument we give on our side of the house, the final benefit, is the second legitimate reason why someone may not want to confess. And that's the idea that ultimately, if an individual fears retribution, even if they agree, even if they feel remorseful, even if they know they committed a crime, they're not going to do so. And ultimately, we don't think it's fair to punish these individuals an extra amount simply because of societal pressures or societal threats that are placed on them, because the police cannot properly protect them, or they don't think their rights will be secured once released in society. Obviously, there are legitimate reasons why people might not confess, and obviously there are utility considerations why we may want to release a person even though he hasn't confessed. Both of those arguments are taken into account on our side, provided on our side, and not on theirs. And for those two reasons, we're proud of you.